Today we're going to be talking about the legal and judicial terminology and working within the juvenile court system. To begin this, we're going to first talk about the philosophy of the juvenile court. Juvenile court cases differ, but also share many of the characteristics of regular trial court. But the main difference between a criminal court or a civil court and juvenile court is that the goal in juvenile court cases is the protection of the child. To that end, we like to use different language within juvenile court than we do within criminal or district court. So we don't have trials. Rather, what we call those are adjudications. We don't have sentencings. We call them dispositional hearings. We don't have findings of guilty or not guilty. Rather, we have findings whether the child is in need of protection or not. We don't impose sentences on parents who have been found to be abused. Rather, we have rehabilitative plans which the parents have to comply with. So some of the key differences in the terminology really boil down to what it is that we use and what we do call something. For instance, in criminal court, we might talk about perpetrators. Well, within juvenile court, we call them the parent, the custodian, the guardian. In criminal cases, we might talk about punishment or jail. Within juvenile court, we talk about services, support, rehabilitation. We talk about children being removed from the home. We talk about termination of parental rights. Those are all just some different type terminology that we do use within juvenile court. Some of the key terms that we need to know within juvenile court, I'd like to go over now. The first one is evidence. What is evidence? Evidence is one of those great legal terms that cover many different areas, but the best way to think of it is that it is any sort of proof that is submitted to the court for the purpose of showing the existence or the non-existence of a fact being true. So that might be anything from an eyewitness testimony, it might be documentation, it might be a photograph, it might be a birth certificate. That is all various different types of evidence. Now, under Nebraska statutes, all of the findings and recommendations made by the Foster Care Review Office that are submitted to a court hearing is considered evidence, and they are to be submitted on the record for the parties to consider. Next term to take a look at is the burden of proof, or the type of proof that is needed. For those of you that watch TV, we know in criminal cases, they always talk about proof beyond a reasonable doubt. And the best way to think of it, whenever I would explain it to people, is to think about the blind lady of justice and think about the scales of justice. And when scales have to tip one way or another, beyond a reasonable doubt means that that scale is tipped 99% one way, that there is not a doubt in your mind that the person has committed whatever act. The second type of burden of proof is known as preponderance of the evidence. Preponderance of the evidence is just like it sounds. It is 51%. So when you think about that scale has been tipped just a little bit on one way. And you call that preponderance of the evidence. In other words, it's more likely than not that something had occurred. The third type of burden of proof that you can have in any case is clear and convincing evidence. Clear and convincing is that type of evidence that is halfway between beyond a reasonable doubt and preponderance of the evidence. In other words, it's about 75%. In other words, it's more than a preponderance, it's more than you know it occurred. You're now sitting in and getting into the fact that you're very positive that it has occurred. And the reason I bring up is the three types of proof is that when we talk about the different type of cases within juvenile court, each of them might use these various types of burdens of proof depending upon the type of proceeding before the court. So now let's talk a little bit about what are the types of petitions that can be filed within juvenile court. First thing to keep in mind that any petition filed within juvenile court is filed and determined by the county attorney of that county. They make the determination as to the type of filing. We have four main types of filings within juvenile court. First, we have what is called the 43-247 subpart 3A. You'll hear it called a lot a 3A filing. What that is it is an abuse neglect of a child. There are two types of abuse neglect cases that can be filed here in Nebraska. One is that the child is being abused or neglected due to the fault of the parent. The other type is that the child is being abused or neglected due to no fault of the parent. Second type of filing in juvenile court is a 43-247-3B. A lot of times you'll hear these called just 3Bs, and that is a status offender. Best way to think of a status offense, it is an action against the child, but it is the type of offense that if you or I committed it as an adult, it would not be an offense. So it includes such things as running away, not going to school, being, common term that they use is ungovernable, being out of control. Third main type is 43-247-3C. You will hear these called a lot of times a 3C case, and that's basically a mental health hold. Because of the mental health of the child, we need to do some action. In adult court, a lot of times we call those competency hearings. In juvenile court, we call them mental health holds. Last type within juvenile court is a 47-247-1 or 2. What the common term that we use for that is the delinquency cases. Those are misdemeanor or felony offenses that have been committed by a child under the age of 18 years of age here in Nebraska. At the time that the allegations or problem or crime are committed or stated, nothing at that time is determined or found or ordered. The petition that is filed, one of the four types I just mentioned, the petition that is filed then determines what the allegations are, what has to be proven by the burden of proof that we just discussed, which then forms the basis of the court's jurisdiction. In other words, the court's intervention, the ability of the court to then go forward. Whenever a child is removed from a home, and I'll talk about this in more detail in a little bit, by either law enforcement or Department of Health and Human Services, or due to a crime or a delinquent act, there's a statutory requirement that that petition by the county attorney has to be filed within 48 hours. If that petition is not filed within 48 hours, then no charges are filed and the child and the parent are free to go. Next term to talk about is protective custody hearings and also detention hearings. Those are two types of initial hearings that come up depending upon the type of the case. In abuse neglect cases and in cases where the child has been removed from the home at the time of the filing of the petition, there is going to be a protective custody hearing. Most courts try to hold that hearing anywhere within 3 to 10 days of the time the child was removed from their home. The whole basis of that hearing is to determine whether or not there is probable cause that exists that warrant that that child should continue to remain out of home. That is the only issue before the court at that time. The other allegations in the petition are not. All the court is looking for is, can the child be returned home or does the child need to be remained out of home? So in abuse neglect cases, it's called a protective custody hearing. In delinquency cases, you will hear them called detention hearings. Detention hearings are where the youth committed a delinquent act, has been removed from the home. Usually that means they have been placed in a detention center. And that hearing has to occur usually within 24 hours, most of the courts do, to determine whether or not that youth should remain in a detention center. So we have protective custody hearings, we have detention hearings. The next type of hearing that you will see, the next term that you need to know, is an adjudication hearing. If you remember, I talked about the fact that we don't call things in juvenile court trials. Instead, we call them adjudication, an even longer word for people to understand. But adjudication hearings are an actual trial on the record with the rules of evidence applying to determine whether or not what was stated in the petition is true or not. By law, these adjudication hearings are to occur within 90 days. These adjudication hearings can either be contested, where the parent or the child on a delinquency is disputing the facts, or they can be uncontested. If they are uncontested, the parent or the child can either admit the allegations or they can plead no contest to the allegations, which for all practical purposes from that day forward, that no contest plea is taken as an admittance of the facts. Rules of evidence do apply to these hearings, so it is just like a trial in any other courtroom. Now, with regards to the Foster Care Review Office, we cannot intervene at the adjudication level. In other words, we can only intervene after the case has been adjudicated and the court has established the jurisdiction. The burden of proof with regards to this adjudication hearing, when you're dealing with abuse neglect cases, the burden of proof is that preponderance of the evidence. In other words, 51%, it's more likely than not that the parent did the acts. When you're dealing with delinquency cases, that burden of proof is higher. That burden of proof is just like any criminal case, and you're looking more at beyond a reasonable doubt that that child committed the crimes. Next hearing that you will see, and a term that you will have come up, is called dispositional hearings. Again, we don't call things sentencings in juvenile court, we call them dispositional hearings. This is a time with the court, especially, first let's talk about abuse neglect cases, where a plan is ordered which addresses the reason that a child or youth came into care. If the adjudication was for a delinquency, there will also be a dispositional hearing, but what we're looking at is what is the child going to be required to do in order to compensate or make up for the delinquent act. So it might be such things as probation or evaluations. Now, the court is limited at these dispositional hearings to develop a plan only based upon the issues that were adjudicated. Now, that becomes very important, and we'll see this come up in many cases where maybe the county attorney in the pleading has alleged that the parent has a dirty house, that the parent uses drugs or alcohol, and that the parent has not taken the child to school. Well, at the time of the adjudication hearing, the parent admits to the dirty house, but does not admit to the other two allegations, and the county attorney dismisses those two allegations. That dispositional plan, that hearing, can only address the issues surrounding the dirty house. You cannot address the other two issues because the parent has not had due process of law and had those allegations proven against them. Now, when it comes to dispositional hearings, the formal rules of evidence do not apply. So what that means from a practical standpoint is letters from doctors, school records, any type of documentation comes into court without the author of that documentation having to be present in court. If the formal rules of evidence applied, they would have to be there. But being it's not, all that type of evidence comes in. This is also where you will usually see your first court report case plan being submitted by the Department of Health and Human Services on abuse neglect cases, or by probation on delinquency cases. In other words, what is their recommendation that the court should be doing on the case? The next type of hearing that you will see is called review hearings. Under statute and under federal law, these review hearings are to take place every 6 months. And the whole object of a review hearing is to see how the parent or the child is progressing on that dispositional order from that hearing, from the dispositional hearing. The focus really should be on progress and what efforts are being made to correct the problem. There will be an order from all review hearings, and also there needs to be a finding under federal and state law if the child is out of home, whether or not that child needs to remain in out-of-home care. Another type of documentation that you may see in some of the cases when you look at them are what's known as supplemental or amended petitions. So you have that original petition that's been filed. The county attorney could choose to amend that petition, in other words, to add new allegations against that parent that is the basis of the original petition, or the county attorney could decide they want to file a supplemental petition. A supplemental petition is just like it sounds. It is new information that has come to light. Mainly where we see supplemental petitions in juvenile court deal with another parent. So maybe the case came in originally with a petition filed against the mother for some actions of the mother. As the case has progressed, we now understand and realize there is a biological or legal father. There may be a supplemental petition now filed against that father, so that then that father would also be entitled to due process rights and to go through the adjudication hearing and the dispositional hearings just as on the same. Another common type of supplemental petition might be the type of petition where originally it was filed against maybe only one or two of the children in a household, and then as more information comes to light, you file a supplemental petition to add other children in that household. Again, due process would apply, so you'd have to go through all the things that we've just talked about. Sometimes you will also hear, especially outside of the urban areas, in the rural areas, you will hear courts talk about journal entries. What a journal entry is basically a court order made by that court, but it is done in a different format, so it's called a journal entry. It's more of a computerized form. But basically a journal entry is a court order or statement as to what occurred at the hearing and what should be happening from then on. Another type of term that you may hear as you're looking at some of these cases is an ex parte order. Ex parte is a Latin term meaning it's a hearing without the parties being present. So you might have a case that is going along and the children have not been removed and there's an emergency situation. You could file an ex parte motion and an ex parte order that a judge would either sign or not sign that then would remove the children from the home. Or another common place where you might find an ex parte motion and order deals in visitation. It may be the type of situation where the parent is having unsupervised visitation due to issues that have arisen in the unsupervised visitation. The county attorney or the guardian ad litem is filing a motion with the court, ex parte motion, in other words, without the parties being present, saying that we need to go to supervised visitation due to the safety of the child. Now, one thing to remember with ex parte motions, again, because of due process and our Constitution, every time there is an ex parte motion and order that is signed by the court, being it is without the parties being present, there has to be a hearing set after that order has been signed. At that hearing, then it is determined whether or not that ex parte order should stay in effect or not. Because otherwise you would lose your chance in court as a parent or as a child to say your side of the story, so due process requires that a hearing be set. Some other type of motions you might see within juvenile court. The first one is a motion to recuse. And basically what that is that when one of the parties has a conflict or wants to be removed from the case, that you are requesting the court to remove that party. Sometimes you'll even see a motion to recuse a certain judge. It may be that they feel that the judge knows too much information or has dealt with this family before and that there needs to be a new judge on the case. Another common motion that we find in juvenile court is our motion to continue. Now, any party to a case, any attorney to a case can file a motion to continue of any hearing. So what becomes more important is the reasons for the motion to continue and how long that continuance is going to be had. Now, a motion to continue is at the total discretion of the trial court judge as to whether or not he or she allows that motion to continue to occur. The last thing that I do want to talk about with regards to motions that you might see, and I'll talk about in more detail later, is a motion for termination of parental rights. This is a specific legal proceeding that severs the parental rights between that particular parent and that particular child. With regards to motions for termination of parental rights, the formal rules of evidence do apply. The burden of proof is higher. In other words, it's clear and convincing evidence instead of a preponderance of the evidence because of the severe sanction that you are doing for a parent if found true. When you're dealing with Indian child welfare cases, that burden of proof to terminate parental rights goes to beyond a reasonable doubt. Terminations of parental rights can be filed by two parties. Those motions can be filed by a county attorney. They can also be filed by a guardian ad litem. The other thing to keep in mind is once you file a motion for termination of parental rights, in many respects it is considered as a new action. So what that means is there will be an arraignment hearing where the parents are read their rights. There will probably be pre-hearing conferences, and then there will be a formal trial on the record. One thing that we always like to keep in mind as we're reviewing files is to make sure that the rights of any and all parents are addressed in these termination petitions. Because reality is if we don't do that, then that termination could be found void by any appellate court, and that is the last thing we want to do to a child. If a parent cannot be located, again, being it's considered a new action, a motion for termination of parental rights, you have to serve that motion for termination of parental rights on a parent by the sheriff or by some other type of service of process. If you cannot get that parent served, then under Nebraska statutes, you can do notice by publication where you publish once a week for 3 weeks in a newspaper so that those actions can still go forward, but it is a different procedure that you have to do because you cannot terminate parental rights without proving to the court that you have good service of process. In other words, that that parent has been notified of the termination proceedings. So maybe what we should do for a little bit now is talk about some of the grounds for termination of parental rights. All of the grounds for termination of parental rights are found in Nebraska Revised Statutes 43-292. And basically, termination is a two-part test that the county attorney or guardian ad litem has to show to the court. First, they have to show one of the specific grounds that are set out under 43-292. If they're able to show one of those grounds, the second thing that they have to prove is that it is in the child's best interest. And if you do not show both of those parts, then that trial court or the appellate court will not find for termination. So with regards to termination of parental rights, let's first talk about some of the grounds. One of the grounds might be under subsection 1 that the parent has abandoned the child for 6 months or more immediately following the filing of the motion or petition for termination of parental rights. And most of the appellate cases are very clear that is a 6-month time period. In other words, not 5 months and 10 days, but 6 months. And there has to be an intentional abandonment. In other words, just because a parent is in jail is not enough to show that the parent has abandoned the child. You have to show that the parent intentionally abandoned. So usually you are looking for, has the child visited the parent in 6 months? Have they tried to visit the parent? Have they contacted the child? Have they sent the child any gifts? That's more what you're looking for to prove the intent, because the key here is intentional abandonment. Second type of termination is a 43-292 subpart 2, and that's where the parents have substantially and continuously or repeatedly neglected a child. 43-292-2, one of the keys to this is that the substantial and continuous or repeated neglect does not have a time period to it. So in a filing of a case, you could allege termination of parental rights at the time that original petition is filed, and it would be under 43-292-2, because that parent has such a history of substantial and continuous or a repeated neglect. The other key of 43-292-2, the substantial and continuous, is that this neglect can be of a sibling of a child. So I'll give an example that would be a common way that we would plead or use 43-292-2. It might be where the parent has 2 or 3 children. They have been working with the court. They haven't complied with a plan, and then they have an infant, and that infant now is 2 or 3 months old, but they really haven't done any type of plan with regards to that infant. You do not have to wait until that infant has been in care for 15 months to terminate. You can say because of the substantial and continuous neglect of the siblings of that infant, you can terminate also the parental rights of that infant. Number 3, so subpart 3 of 43-292, deals with the situation where the parents are financially able but have willfully neglected to provide for the basic needs of the child. In other words, a roof over their head, clothing, education, or the other care necessary. It might be that they're refusing to get medical care for the child and the child needs it. That is probably one of the least common termination of parental rights basis, because again, the key to this one you have to show is that the parents are financially able, and sometimes that's a very difficult burden for county attorneys to prove. Subpart 4 of 43-292 deals with the situation where the parents are unfit because of debauchery, and if you can define that, you can tell me, or the habitual use of liquor or alcohol or drugs or lewd or lascivious behavior, which is a serious detriment to the child. So these are the type of cases where maybe the parent has a very severe drug or alcohol problem and it has just made them unfit to parent. Number 5, the subpart 5 of 43-292, deals with those situations where the parent is unable to parent due to the parent's own mental health issues or mental deficiencies. What case law is very clear that if you are going to try to terminate because of the parent's mental health issues or deficiencies, that parent must be appointed their own guardian ad litem within that proceeding that is looking out for their best interests. Because what we are saying is that that parent cannot parent because they have a severe mental health, then how can they then actively participate in a court trial? So those are the type cases where you will see the parent have their own guardian ad litem along with their attorney. Now the key to the mental illness or mental deficiency is that the county attorney or guardian ad litem has to show in court that that condition, mental condition, is going to continue for an indefinite time period. So it's not just the parent that maybe has mental health issues but has the ability to parent and is just going through a rough spot. You have to show through expert testimony that that parent, no matter how good they become, will never be able to parent. Number 6 is probably the most common subset that is used in a termination of parental rights. Number 6 and number 7, but number 6 deals with reasonable efforts. Reasonable efforts is when the parent has had a plan through that dispositional hearing and review hearings that we just talked about. The parent has been on a plan, the parent has been offered services, but the parent has failed to correct the conditions that brought that child into care. What commonly goes with the subset number 6 is subset number 7. You will see this a lot too, and you'll hear us talk a lot about the fact that the juvenile has been in out-of-home placement for 15 or more months out of the most recent 22 months. So that's where that 15 months time comes in. And you'll notice I said 15 months out of the most recent 22. So really what you're looking at is for those youth that are in home and out of home, if you added all those time periods together within 22 months, do you reach 15 months? Now, 15 months is probably, from a county attorney or guardian ad litem standpoint, one of the easier sessions to prove because it's all a matter of numbers. But I hesitate and want you to keep in mind that that's only reaching the first burden you have to meet in a termination of parental rights, you still have to show that it's in their best interest. So just because that child has been out of home 15 out of 22 months doesn't mean that there is an automatic termination of parental rights. Subsect number 8 under 43-292 deals with a parent who has inflicted intentionally serious bodily injury on the child, other than accident. In other words, the parent has intentionally done the action. Subset number 9 under 43-292 is when the parent of the juvenile has subjected the juvenile to abandonment, torture, chronic abuse, or sexual abuse. It's very specific in statute that you have to meet one of those type of requirements to show aggravated circumstances. Number 10, 43-292-10, was added by the legislature to deal with a parent who has committed murder of another child and has other children, or voluntary manslaughter, or has done a felony assault on one child but hasn't hurt the other child or other children. So what you can allege, and if you can prove it, is that the parent has inflicted injury on their first child, on Johnny, and because of the serious injuries they did to Johnny, then termination of parental rights should occur on all their other children. So those are the grounds for the termination of parental rights. And like I said, keep in mind that you have to show one of those 10 grounds and also best interest. And more, the Court of Appeals is really looking at what is the testimony with regards to best interest. And when you look at best interest, you are usually talking about what is the expert opinion of the therapist involved, of maybe the psychologist involved, of the family support workers, the people that are working with the family. Do they feel it is in that child's best interest? It might even be the caseworker that is testifying as to best interest. But the Court of Appeals and the trial courts are really looking in more detail as to best interest. Is it really in the best interest? I will give you an example. You might have a 16-year-old child who has been continuously out of home for 15 out of 22 months. So you have that portion of the termination statutes met, but maybe that 16-year-old child still has a relationship with the parents. Or maybe there's no permanency for that child. So really it is their best interest to terminate those parental rights. You need to really look at both parts every time you're evaluating a case with regards to termination. So next part with regards to the court process deals with appeals. Appeals are when the parents resort to a higher court than the juvenile court or the county court sitting as a juvenile court and are asking the Court of Appeals or the Nebraska Supreme Court to look at a case and see if the proper decision was made by the trial court. Now, what can be appealed are many things within juvenile court. It could be that original adjudication. It could be a dispositional hearing. It could be a termination of parental rights may be appealed. Okay? If the case is on appeal, then that case is now being handled by the Court of Appeals or the Supreme Court. Last area that I want to visit before we talk about the process for abuse neglect cases is to talk about visitation. One of the areas that we really want to concentrate is to really watch those court orders to ensure that they address visitation in every case, especially when visitations are supervised or unsupervised. What is the court ordering? Sometimes you will even see a separate letter to the court asking the judge to approve certain types of visitations or changes in visitation. What the Nebraska Supreme Court has found is that the Department of Health and Human Services does not have the authority to determine or place restrictions on visitations, only the court does. So we need to be very clear in these visitation orders what that visitation type is to be, supervised or unsupervised or semi-supervised, and then secondly, how often is it to be occurring? Because there's a lot of research out there also with regards to visitation, that visitation is one of the key factors to look at as to the success of a reunification or not. So we are trying to pay very close attention to those visitations. Are they occurring? Are they appropriate? Should they be happening? And is it in those child's best interests? So now let's talk a little bit about the juvenile court process for abuse neglect cases. And later we will be doing also video with regards to the process for delinquency cases. But right now we want to talk about abuse neglect cases. Remember that the Foster Care Review Office has authority to review the case of any child at any time they are removed from the family home. So that includes non-court cases if that child is out of home, and it includes court cases if that child is out of home. So typically we review information that's gathered from all the legal parties prior to a court hearing. We bring them to the local board, and then we share our recommendations and findings with the court so that the court can address any concerns that we have. So the process, how does a child even get into the process for an abuse neglect case? First, there is usually a report of child abuse or neglect. This can be made by anybody, and when you look at Nebraska statutes, most of us, if not all of us, are mandatory reporters. That if we see child abuse or neglect occurring, we need to call the hotline and report it. And so these reports could come from medical personnel, or they can come from schools, neighbors, foster parents, social workers. The list goes on and on as to when it could. When that happens, the call goes into Health and Human Services hotline. That hotline then has a tool, a validated tool through structured decision making, where they are deciding whether or not that report is either accepted or is it going to be screened out. If it is accepted under current Nebraska statutes, that case will then be set for an investigation by Health and Human Services. If it is screened out, then that report of child abuse or neglect is gone. A record will be kept of it, but there will be no further action on that screened out report. Now, what is an investigation? So let's say that a call comes into the hotline has done the screening of it, and they have determined that the report is being accepted, and they have now set it for an investigation. There are two parties that could be part of the investigation. The investigation could involve law enforcement if there's also a criminal activity involved, and or Child Protective Services, Division of Health and Human Services. So you will hear many times people talk about the initial assessment worker, that IA worker. The IA worker, initial assessment worker, is really the one doing the investigation to determine whether or not the allegations or concerns in the report rise to the level that we need to do some filing within court or services need to be offered to the family. All of that part of the investigation that is done by both law enforcement and the initial assessment is then screened and looked at by a county attorney. That county attorney then looks at it and determines whether or not they are going to file a petition within the juvenile court in order to deal with the action. The county attorney could decide they're not going to file. That is a county attorney judicial discretion that they have as to whether or not they're going to file. Now, if at the time of the investigation, the initial assessment unit feels that the child needs to be removed from the home because it is an unsafe situation, that worker can get an affidavit, which is a signed statement, to the county attorney requesting that that child be removed immediately. That county attorney must act on that within 24 hours and either determine that, yes, we are going to file that ex parte, that out-of-court motion in order to remove that child from home. If the county attorney files that ex parte motion to remove the child and the judge agrees, it will usually be then a sheriff's office or law enforcement or an initial assessment worker that then will physically remove those children from that surrounding. Now, when that happens, that ex parte removal, There then will be, just like we talked about, that protective custody hearing within the court to determine whether or not that child should remain out of home. Now I want to back up just a minute too, because what might happen in this beginning portion of any case is that sometimes instead of people calling the hotline, when they're concerned about a child, they will call 911, which is acceptable too. So a call comes into 911 from the school or from the neighbor concerned about a child. When a call goes into 911, then the law enforcement goes out to investigate the situation. The law enforcement, when they go to that house, have the legal ability to make the determination that that child is unsafe and I am going to remove that child now. Only law enforcement under Nebraska law has the authority to remove a child from home without a court order. Everybody else requires a court order. So sometimes in an emergency situation or when we are concerned about the safety of a child and you think something has to be done immediately, we need law enforcement to get involved to go look at the situation and determine whether it's unsafe or not. Now, when law enforcement removes the child because they determine that the child is unsafe, it happens the same way that we just talked about with regards to the initial assessment unit. In other words, law enforcement then will do the affidavit, get it to the county attorney's office. The county attorney's office will review that documentation. The county attorneys will then decide what type of petition they're filing, and then are they going to file an ex parte motion in order to remove that child from the home. So we've already talked about the different types of petitions that the county attorney can file. And we've already talked some that after the filing of the petition then, we have the protective custody hearing. Now, let's talk just a little bit more about protective custody hearings, what happens there. What happens is first, legal rights are explained to the parents so that they know due process requires that they are made aware of what their rights are. It also requires that they be told what happens if they don't follow the court's order. In other words, you have to give them notification that if they don't, their parental rights could be terminated. And we need to tell them that up front. More than likely at the protective custody hearing, a guardian ad litem will be appointed. A guardian ad litem is a special type of attorney under Nebraska law. It must be an attorney that is appointed to represent the child's best interests. And I want to stress that it is the child's best interests, not always what the child wants, but what they feel is in the best interest of the child. And we will see that come up in cases, especially with teenagers, where maybe the teenager, that 14, 15-year-old wants something specific to happen, but their guardian ad litem that is looking out for their best interest says that's not in that child's best interest. Also at this protective custody hearing, the parents may be appointed attorneys. We are strong advocates as an agency that parents should always be appointed attorneys at protective custody hearings because you are dealing with substantial rights of a parent to parent a child. This hearing, that protective custody hearing, like we discussed, also then looks at, is there probable cause that that child should remain in out-of-home care? Testimony can be taken at a protective custody hearing, or the parent could decide not to contest the protective custody hearing. It also could happen in a case if a child has not been removed. At this hearing, the child could be removed at that time because the court has concerns. Now, whenever a child is removed from their parental home in an abuse neglect case, the Department of Health and Human Services is given custody of that child. They then become responsible as a locus parentis, they call it, to be responsible for that child's placement, their plan, their services, all the type needs that that child might have. So in other words, the parents are not that legal custodian any longer. It is the Department of Health and Human Services that is. Now, A couple other things that might happen then after that protective custody hearing, like we talked about, there then will be an adjudication hearing. We've talked some about how the fact there may be what is commonly called plea bargaining, where the parent might admit to one or two of the allegations, but then the rest of the allegations are dismissed. There might be an actual trial on the evidence, where the burden of proof is for the county attorney to show or prove that what the parents have done. It's basically a finding of fact. Are the allegations of the petition true or not? Then after that adjudication hearing, like we talked about, then occur that dispositional hearing, and then also the review hearings, and then the permanency hearings. Now, one thing that the law does require, besides those review hearings every 6 months, is that at 12 months, there must be a permanency hearing. So in other words, after that child has spent 12 months in out-of-home care, the court must hold a special hearing to determine what is the most appropriate permanency for the child. So as you're looking at these case file reviews that you're doing, you'll notice we talk a lot about what is the case planned permanency that the department is recommending, and then what is the court ordered permanency plan. This is what happens at a permanency hearing. What are we looking to do? Are we looking for reunification? Are we looking for adoption? Are we looking for guardianship? Are we looking for independent living? Those are all type of things that go into a permanency hearing. Part of our role as the foster care review office in our oversight is to ensure that those hearings are occurring at the appropriate time period, and also that the right information is there and that the court is making the decisions that they have to make. There's one other section that I want to talk about, and then we'll conclude with regards to the process of abuse neglect cases. We've already talked about the termination of parental rights, what has to go in proving that part of it. What we haven't really talked about is what also might happen, and that's called parental relinquishments. In other words, a parent can decide through actions of their own that they are going to relinquish their parental rights to that child to Health and Human Services. Now, many times HHS will only accept a relinquishment if both of the parents are willing to relinquish, or if they both sign, or if at least one of the parents has been terminated on. There are certain, of course, exceptions to that I have seen done. And it might be the situation where, I remember one specific case, so I'll just use it as an example, where it was a mother and the father had sexually abused the children. The mother wanted to relinquish her parental rights, but the department was not willing to do that until the father had relinquished. So sometimes what they will do is they will wait for the mother to relinquish until the father's rights are terminated. I also had the exact same situation come up where just the opposite, where the father who had sexually abused the children had relinquished his parental rights. Because of the severity of the situation, the department did accept that relinquishment without accepting any from the mother at that point. So sometimes it does happen, but really the department likes to do it at the same time, because then the child is free for adoption. Now, one thing that does come up with regards to once parental rights are either terminated or relinquished is with regards to open adoptions. Open adoptions it's a legally enforceable contract between biological parents and adoptive parents. There is very much a question here in Nebraska how enforceable those are in court. So we would always be very cautious in telling either the biological parents or the adoptive parents whether or not they can ever enforce those in court if somebody doesn't. But many times, especially with relatives, the department will look at doing open adoptions, because reality is they may still be seeing their biological parents. That let's have an open adoption agreement, It might be as simple as some of them I've done where pictures are exchanged every year, or report cards are, or the adoptive parents may send information to the biological parents just as to how the child's doing. So those open adoptions can be as open or as non-open as those adoptive parents want it to be. So that pretty much is the juvenile court process in child abuse and neglect cases and some of the background. If you ever have any further questions, please don't hesitate to let us know or give us a call, and we will gladly get you the further information. Thank you for your time, and hopefully you have enjoyed this video.